I'm going to reveal 3 key secrets about court documentation that can make or break your U.S. entry waiver application. I'm Dan Joffe, dedicated U.S. entry waiver lawyer at NextLaw. When it comes to U.S. waivers, court documentation is often the biggest stumbling block that can delay or even derail your entire I-192 application. In this video, I'm going to break down the 3 crucial things you need to know about court documentation for your U.S. waiver. By the end, you'll understand exactly what you need and how to avoid the common pitfalls that can cost you time and money, and worst of all, result in your waiver application being denied. Part 1, the court documentation basics. Let me break down exactly what court documentation means for your waiver. Think about it. When applying for a U.S. waiver, you can't just say, I had this conviction. The United States government needs proof, and that proof comes from your court documentation. Here's what you need to provide, and pay close attention because this is where most people go wrong. For every single conviction, you need the full official record. I'm talking about the actual conviction documents, the court dispositions, anything about parole or probation, and even documents about pardons if you have them. And if, for some reason, you can't get these records, you'll need an official letter from the court explaining why. If your documents aren't in English, you can't just translate them yourself or use Google Translate. You'll need a certified translation with the translator confirming that they're qualified to translate and it's accurate. I've seen many applications get stuck because people miss these requirements. Part 2, the truth about processing times. Now here's something that might surprise you about getting court documentation. Not all courts are created equal. Let me explain what I mean. Some courts in Canada will get you files in a few weeks, but others can take many months. I've had clients who thought they can just walk into any courthouse and get their documentations the same day. That's not how it works. Each court has its own process, its own timeline, and its own way of handling requests. And here's the thing, you can't speed this up. The courts move at their own pace. Part 3, impact on your waiver application. This is where everything comes together, and it's critical you understand this part. Your waiver application is only as good as your court documentation. Let me be clear. If your documentation is incomplete or inaccurate, your waiver application could be denied no matter how strong the rest of your case is. Most people don't realize that the US government uses these court documents to decide your admissibility. They're not just checking boxes, they're looking at every detail. If something doesn't match up, if there's missing information, this could all lead to a denial. Remember this, some service companies don't properly document information for a waiver application. Unlike lawyers with years of legal training and experience, these companies often lack the legal expertise to handle documentation requirements correctly. I've seen cases where people had to start their application over because the documentation wasn't handled correctly by someone who wasn't properly trained in law. So there you have it, the 3 crucial things you need to know about court documentation for your U.S. waiver. If you need help with your U.S. waiver application, schedule a free confidential phone call with me. The link to book the call is in the description of this video. Thanks for watching.